Attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation in a LawCast series talking about Regulation A. Form 1A consists of three parts. Part 1, notification. Part 2, the offering circular. And Part 3, exhibits. Part 1 calls for certain basic information about the company and the offering, and is primarily designed to confirm and determine eligibility for the use of Regulation A in general. Part 1 also includes disclosure related to the application of the bad actor disqualifications, jurisdictions in which securities are to be offered, and unregistered securities issued or sold within the prior 1 year. Part 2 is the offering circular and is similar to the prospectus in a registration statement. Part 2 requires disclosure of basic information about the company and the offering, material risks, dilution, a plan of distribution, the use of proceeds, a description of the business operations, description of physical properties, discussion of financial condition and results of operations, MD&A, identification of and disclosure about directors, executive officers, and key employees, executive compensation, beneficial security ownership information, related party transactions, a description of offered securities, and 2 years of financial information. The required information in Part 2 of Form 1A is scaled down from the requirements in Regulation SK applicable to a Form S1. However, companies can complete Part 2 by either following that scaled down Form 1A disclosure format or by including information required by Part 1 of Forms S1 or S11. Only companies that elect to use the S1 or S11 format qualify to file a Form 8A to register and become subject to the full Exchange Act reporting requirements. Companies that have previously completed a Regulation A offering and have filed reports with the SEC under Regulation A can incorporate by reference in a future or subsequent new Regulation A offering. Form 1A requires 2 years of financial information. All financial statements for Regulation A offerings must be prepared in accordance with GAAP. Financial statements for a Tier 1 offering are not required to be audited. Audited financial statements are required, though, for Tier 2 offerings. Audit firms must be independent and must be PCAOB qualified. An offering statement cannot be qualified if the date of the balance sheet is more than 9 months prior to the date of qualification. A recently created entity may choose to provide a balance sheet as of the date of inception instead of as of the year end, as long as that inception date is within 9 months before the date of filing for qualification, and as long as the date of qualification is not more than 3 months after the entity reached its first annual balance sheet date. The date of the most recent balance sheet determines which fiscal years or periods since existence for recently created entities the statements of income, cash flows, and changes in stockholders' equity must cover. When the balance sheet is dated as of inception, there is no requirement to provide statements of income, cash flows, or changes in stockholders' equity. Part 3 requires an exhibit index and a description of exhibits required to be filed as part of the offering statement. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of LawCast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.